La Cour.
Je déclare ouverte l'audience publique sur le fond de l'affaire von Hannover contre Allemagne. L'affaire a été introduite devant la Cour le 6 juin 2000 par une ressortissante monégasque, Son Altesse Royale la Princesse Caroline von Hannover, en vertu de l'article 34 de la Convention. Elle a été attribuée à la 4e section de la Cour, conformément à l'article 52, paragraphe 1er du règlement de la Cour. Le 1er novembre 2001, la Cour a modifié la composition de cette section. En conséquence, la présente requête a été attribuée à la 3e section, ainsi remaniée. La requête a été communiquée au gouvernement le 4 juillet 2002 et déclarée recevable le 8 juillet 2003. Le même jour, la Chambre a décidé de tenir une audience sur le fond de l'affaire. Le 16 et le 27 septembre 2003, j'ai autorisé l'Association des éditeurs de magazines allemands et la société Burda à soumettre des observations écrites en tant que tierce partie en vertu de l'article 61, paragraphe 3 du règlement. Le gouvernement est représenté par son agent, M. Klaus Stoltenberg, ministériel dirigente du ministère fédéral de la Justice, ainsi que par M. Ansgar Olli, professeur de droit civil à l'Université de Bayreuth, conseil, et Mme Angelika Leitenberg, assistante exécutive auprès de l'agent conseillère. La requérante est représentée par Maître Matthias Prinz, avocat, assisté de Maître Claudia Moffat, avocate, et Maître Alain Touka, avocat. Je salue les comparants au nom de la Cour. Ayant consulté l'agent du gouvernement et le représentant de la requérante, j'ai fixé ainsi l'ordre des paroles. Nous entendrons successivement Maître Prinz pour la princesse, pour la requérante, puis Monsieur Stoltenberg et Monsieur Olli pour le gouvernement. Mr. Prince, the floor is yours.
Thank you, Mr. President. High Court, Your Honors, I'm very honored that I may speak to you here today on behalf of my client.
Sorry, Monsieur, Madame, est-ce que vous pouvez retirer un petit peu? C'est bon, c'est bon. Je vous en prie.
On August 31st, 1997, Princess Diana of Wales died in a road traffic accident after a car chase in Paris. During the evening of her death, photographers had waited outside the hotel where she was dining with a friend. The paparazzi were hunting for photographs which were meant to show her leaving the hotel, entering her car, sitting in her car, and then again leaving the car. All scenes from her private life. Nothing official, nothing to do with a public office. Under French law, the publication of these photographs is not allowed. Pictures showing private life in France may only be published with consent. The French courts rarely make exception from this requirement of consent. Regarding public persons, they assume a consent only in the publication of pictures showing public persons in performance of their public functions. Only then. A legitimate interest in information is accepted if an image pictures the official life of a person, la vie officielle, but not if the image pictures the private life, even if this can also happen in public. Accordingly, while Article 9 of the French Civil Code reads, everyone has the right to have his or her private life respected, one must add, regardless of his or her degree of fame and notoriety. There cannot be any doubt that the photographs of Princess Diana would have been unlawful under French law. Under German law, such photographs are allowed, just as the photographs before the court here today. The Princess of Wales would be deemed a so-called absolute Person der Zeitgeschichte, a person of absolute public interest according to German law, and such persons usually do not enjoy any protection of their private sphere. Protection is only available to them in exceptional circumstances, namely if they resort to so-called örtliche Abgeschiedenheit, local isolation. In principle and in practice, however, the private life of absolute Personen der Zeitgeschichte, these persons of absolute public interest, do not enjoy any protection at all. Princess Diana had not resorted to örtliche Abgeschiedenheit. She appeared before a public restaurant in the streets of Paris and in a car, clearly visible from all sides. Once again, under German law, such photographs are allowed. These different legal situations have the following consequence. French paparazzi follow well-known personalities on French territory to take photographs which may not be published in France. Nevertheless, they follow them because the same photographs may be published in Germany, and there is a large market for such photographs in Germany indeed. One can earn thousands of euros with photographs from other people's private lives. That is why French photographers have a strong incentive to be on the lookout even on French territory and explore the private lives of well-known personalities, to observe and spy on them around the clock and take photographs. After the death of the Princess of Wales, the Parliamentary Assembly of the Council of Europe passed its Resolution 1165 on June 26, 1998, which reads as follows in its number 14. The Assembly calls upon the governments of the member states to pass legislation guaranteeing the right to privacy containing the following guidelines. And one of these guidelines reads, following or chasing persons to photograph, film or record them in such a manner that they are prevented from enjoying the normal peace and quiet they expect in their lives, or even such that they are caused actual physical harm, should be prohibited. In France, such a statute had been in force already long before the death of the Princess of Wales and long before Resolution 1165. In Germany, it still is not available. Therefore, personalities like the Princess of Wales or my client, the complainant, are being hunted and pursued in France and other countries all over the world in order that photographs are taken for legal publication in Germany. The complainant has been suffering from this constant shadowing and spying for years. She and her 4 children are continuously observed, by day and at night, by persons who are dying to take photographs from their private lives and sell them. I have personally experienced this constant shadowing and spying on several occasions when I met my client. There were cases when I suddenly noticed that someone was lurking in a parking car and taking photographs. Or a window opened somewhere and a long telephoto lens emerged. There were also cases when I did not notice the photographer and still found photographs of our meeting in publications several days later. Of course, this observance of myself only took a few hours, and I was able to leave as a free man who can roam about without restrictions. However, the complainant and her children have to live permanently with the feeling that someone is observing them whom they cannot see. Currently, photographers can take pin-sharp photographs from a distance of 1,500 meters. If a photographer looks at his victim through his lens, he can clearly see every detail. If the victim looks in the direction of the photographer, he can see nothing because the photographer is too far away or well concealed. High Court, please imagine the feeling you would be observed every minute you spend outside your home or your office, in the street, during sporting activities, in a street cafe, while you are skiing or cycling, on the beach, always observed and photographed. This constant observance and spying is not only a limitation of privacy, but amounts to a complete loss of privacy. Additionally, there is the feeling of threat. Is it really only photographers which are following and observing you, or criminals, mad assassins or kidnappers? You are constantly followed, and you don't know who is sitting in the car behind you and what he wants. We had cases in which persons spied at the schools of the complainant's children and were waylaying the children, perhaps only to take photographs. But how do you know they are only photographers? The pursuit and shadowing by paparazzi photographers is not different in any way from the pursuit and observation by kidnappers, at least not from the perspective of the one shadowed and observed. Again and again, our client, the complainant, found herself in cases of actual danger. When she fell ill some years ago and had completely lost the hair of her head, our client and her bald head were a welcome victim of paparazzi. Photographs showing her bald head promised a fortune. On a summer day, she drove alone on the motorway, wearing a hat to cover her baldness. Because of the heat, she took the hat off. 2 cars with pursuing photographers tried to push her off the motorway and forced her to stop, so they could take the desired photographs. The situation was so dangerous, it almost led to a car accident, and the complainant nearly ended like the Princess of Wales. My friend and colleague Alain Toucas from Paris has been dealing with this case in France in a criminal case. And he can tell you more about this later if you're interested. In French criminal law proceedings, the eldest son of the complainant made a statement before the High Court in Fontainebleau, and I may quote from his statement. He said, "It is terrible to continuously stalked. I have the impression to have nothing for myself anymore. What is else very stressful is the fact that one has always got to look back and around and examine whether one is not followed. This is a kind of permanent scare. It is a feeling of scare which is very close to what might be paranoia. This must absolutely stop. It has the effect to demoralize my personality, to attack my identity. It is unbearable." There can be no doubt that the constant observation does in fact lead to an almost complete loss of privacy and also to a considerable scare. The situation is an obvious violation of Article 8 of the European Convention on Human Rights and exactly the contrary of the situation which should have been achieved by Resolution 1165 of the Parliamentary Assembly regarding the right to privacy. This unlawful situation is caused by the German courts. The 10 judgments presented to you in our proceedings clearly show that a just and fair balance of the right to privacy on the one hand and freedom of press on the other hand is not happening before these German courts in these judgments. The judgments rather very clearly show the following. At some stage, the courts have taken the view that our client is an absolute Person der Zeitgeschichte, a person of absolute public interest. This automatically goes together with an almost complete loss of privacy. This result has been achieved in spite of the fact that our client does not have a public office, nor a public function. She does by no means desire to be an absolute person of public interest. Only her origin, her birth, makes her an absolute Person der Zeitgeschichte, according to the German courts, and thus a person without a protected sphere of privacy. Article 8 of the European Convention on Human Rights reads, Everyone has the right to respect for his private and family life. There shall be no interference by public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the promotion of health or morals, or for the protection of the rights and freedoms of others. Let us look at the pictures here in front of the court. We first want to look at exhibits BF1, BF2, and BF3. You all have them in the file in front of you, and we brought them a little bit bigger. These three enclosures, I think there are 4 pictures altogether, were subject matter of a lawsuit conducted by the complainant before the Hamburg High Court, the Hamburg Court of Appeal, before the Federal Court of Appeal, and finally the Federal Constitutional Court in Germany. BF1 is a photograph which shows the complainant riding a horse. This is a photograph which is typical for our litigation because it shows the complainant exercising a sport which is normally practiced outdoors. The complainant loves outdoor sports and nature. If we look at these pictures here in these premises, an inevitable question arises from the second paragraph of Article 8 of the European Convention on Human Rights. We have to ask, is it necessary to observe the complainant exercising her private sports pleasures to secretly photograph her from a concealed spot and to publish the pictures? Is it necessary in a democratic society in the interest of national security? Is it necessary in the interest of public safety or the economic well-being of the country? Is it necessary for the prevention of disorder or crime? Is it necessary for the protection of health or morals? Is it necessary for the protection of the rights and freedom of others? No. I think it's quite clear that these pictures are not necessary for any of these outstanding values in a democratic society. Let's have a look at photograph BF2. Is it necessary in a democratic society in the interest of national security, public safety, the economic well-being of the country, for the prevention of disorder or crime, for the protection of health and morals, or for the protection of the rights and freedom of others, to show how the complainant looks walking in a street? I think clearly no. Is it necessary to show how she looks on a bicycle? Or is it necessary to show how she looks in a restaurant when she's drinking a glass of wine and smoking a cigarette? Well, I think clearly no. Much as I may like, I cannot see how these photographs should have any significance whatsoever for a democratic society. But even if we would recognize a significance, this would not be sufficient. Article 8 of the European Convention requires that it has to be necessary in a democratic society. And I think it is pretty clear that none of these pictures are necessary. Why have the German courts then held these photographs to be lawful? That is shown by the decisions which have submitted to this court. If you look at the decisions BF4 and BF5, you can see that it is generally decided that the complainant is an absolute Person der Zeitgeschichte, a person of absolute public interest, and therefore has to accept all publications. There are no individual reasons. The Federal Court of Appeal agreed in its judgment submitted to this court as enclosure BF6. The Federal Court of Appeal also assumes that an absolute Person der Zeitgeschichte has to tolerate any photographical reporting outside his or her own home in principle. The court did make a small exception for the first time. There shall be a minute scope of private sphere also for absolute Person der Zeitgeschichte, if they have retreated to a so-called örtliche Abgeschiedenheit, local isolation. Other than persons to Article 8 of the European Convention, the loss of the private sphere is therefore in Germany still the rule for absolute Person der Zeitgeschichte, and the protection of the private sphere is a particular exception of this rule, demanding a retreat in local isolation, almost into a kind of hiding. However, even this exception is without any significance in practice. The complainant and her family are still shadowed and followed around the clock, so that it is impossible already for practical purposes for her and them to hide in local isolation. If she does in fact manages to retreat, the lawyer arguments begins. We had a case when pictures were taken on a boat moored offshore in a storm. How far does the boat have to be away from land to be in local isolation? A member of our firm traveled to Mallorca in order to inspect the moorage of the boat that had cast anchor 100 meters off the coast of Mallorca. And our young lawyer found that the boat was so far away from the harbor that no one could see the persons aboard with naked eye. So we assumed that this is local isolation and started litigation. In our proceedings, the court declared it would assume local isolation and therefore a protected privacy only if the boat moored more than 100 meters away from the coast. Now that clearly shows that you have to go very, very far out to enjoy any kind of protection of privacy, and as soon as you get closer of 100 meters to land, your privacy disappears. In this case, the captain of the boat had to be examined as a witness, the nautical map and the logbook were scrutinized, the publisher had the photographer flown in from the Caribbean so that he should confirm the boat was closer to the shore than 100 meters. A considerable effort was undertaken until it was finally clear that the photographs were unlawful because the boat had in fact moored farther than 100 meters offshore. Still, the complainant had been observed on the boat, and she had of course also been observed and photographed on the way to the boat and on the way from the boat, because photographs on the way towards local isolation and away from local isolation are still allowed under German law. That is to say, the small exception of örtliche Abgeschiedenheit, local isolation, is completely without significance in practice and does only lead to complicated and costly litigation, because the complainant must prove that there is local isolation. In fact, this small exception has not truly changed anything at all. All photographs which are available to you here today are still allowed according to the opinion of the German courts. This is only justified with the argument that the complainant has to tolerate limitations of her private sphere because she is an absolute person, eine absolute Person der Zeitgeschichte, a person of absolute public interest. There are no reasons which justify in any way whatsoever why this limitation of the private life should be necessary within the meaning of Article 8 of the European Convention on Human Rights. The German courts obviously have not even considered Article 8 of the European Convention in any of their 10 judgments. You don't find any mentioning of Article 8 in any of the judgments in front of you. Instead, the German courts have assumed, without independent arguments, that the complainant has to tolerate all photographs merely because she is a person of absolute public interest. Let's have a look at the next case. Enclosure BF11 in front of you shows photographs of the complainant during her skiing holidays. A typical private situation. The complainant moves about like any other tourist in the ski resort, at the hotel bar, at the skiing lift, and on skis. All German courts concerned with this case unanimously decided that the complainant, as a person of absolute public interest, has to tolerate this publication. If we examine the photographs and once again recall the wording of Article 8 of the European Convention on Human Rights, it is completely evident that these German judgments are unlawful, because none of the decisions which so much as a single word hints why it should be necessary in a democratic society in the interest of national security public safety or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others, to show pictures of the complainant during his skiing holidays. Let us turn to enclosure BF12. There we see the complainant on a paddock or on a parking lot, close to a paddock. It is absolutely inconceivable why the publication of these photographs should be necessary for any interest in a democratic society. Enclosure BF13 shows the complainant and her husband playing tennis. The couple is on a small private hotel tennis court. Like on all other available photographs, we can see two aspects. The complainant is photographed from a hidden position. Obviously, she doesn't notice any intrusion. The photographs show the complainant in private situation which one cannot experience at home. Anyone who enjoys riding horses, skiing or tennis has to go out. One needs a paddock, a tennis court or a skiing lift. One cannot lock oneself in at home, and it is virtually impossible to practice these sports in local isolation. According to the German courts, the complainant, therefore, does not enjoy the right to ride, ski or play tennis, unobserved and unphotographed. The German courts allow the complainant to be pursued and secretly photographed upon these typically private occasions and then be presented to millions of people so that some media enterprises can earn money. This is the only true reason there is. Clearly, there are no reasons of necessity in a democratic society. It follows that the German courts achieve the complete opposite of what Resolution 1165 of the European Parliamentary Assembly regarding the right to privacy demands. The German courts do not protect the complainant nor her family against pursuit and continuous observation. On the contrary, they even give an incentive, making a commercial exploitation of the private life possible, and thereby establishing the permanent pursuit of the complainant and her family as a proper profession sanctioned by the legal order. Paparazzi are man-hunters endorsed by the German legal system. The interests of the complainant and of her family in unobserved private lives are outbalanced by the commercial interests of photographers and media enterprises, according to all the judgments available here. Let us now please turn to the last and final case, enclosure BF18. You will find photographs of particularly bad quality which have been taken from several hundred meters distance, spying into the premises of the Monaco Beach Club. The photographs must have been taken from a window or the roof of a property in the vicinity. The Monaco Beach Club is a private beach club, the entry being subject to a fee. As the pictures show, the complainant went there to swim and lie in the sun. Compared with the other photographs we have already seen today, these are surely the most humiliating. They show the complainant falling and lying on the ground. Nevertheless, the German courts consider these photographs legitimate. There can't be any doubt in these circumstances. The German courts apparently violate and disregard the complainant's human right in respect of her private life. There can't be any question that the scene pictured here is private. The complainant is on private premises and enjoys a private occupation. In spite of that, these photographs shall be allowed by the German courts. The complainant is humiliated and turned into a mere object of voyeurism, like an animal in a zoo. Of course, there is no justification within the meaning of the second paragraph of Article 8 of the European Convention on Human Rights. It is absolutely impossible to justify that it should be necessary in a democratic society to show the complainant lying on the ground, flat on her stomach, in the interest of national security, public safety, or the economic well-being of the country. If this result must be so unambiguous in view of the wording of Article 8 of the European Convention, which I have read out to you several times, one can easily understand why the German courts have not sought to find a single word of reasons how their decisions could be justified in view of Article 8. It is also obvious from the statement of the federal government in the present case that such reasons cannot be found. Even under close scrutiny, one won't find any reasons in the statement of the Federal Republic of Germany why all these photographs showing the complainant in her private life should be lawful in view of the clear wording of Article 8 of the European Convention on Human Rights. Finally, a comparison with the French law clearly shows that there is no such necessity for a democratic community. As I have explained, all these photographs would be unlawful in France. None of these photographs could be published there. Still, there are no problems in the French legal system with national security, public safety, or the economic well-being of the country, which might make it necessary to allow such photographs in France. Of course, the democratic society in France manages very well without such intrusions, and there is no doubt that France enjoys all the benefits of freedom of press. It follows that the democratic society in Germany would also manage without such intrusions. The intrusions into the private sphere of the complainant, which I have shown, are by no means necessary and thus clearly violate Article 8 of the European Convention on Human Rights. Thank you.
Monsieur Stoltenberg,
Vertreter der Beschwerdeführerin zu übergeben. Vielen Dank.
Merci. Est-ce que mes collègues ont des questions à poser? Monsieur John Edigan, en anglais.
Thank you, President. Thank you very much for the very helpful and learned submissions, which I found very helpful. I have just one question. Mr. Prinz seemed in his submissions to me, in his reference to the situation of Princess Diana in France, where the photographs of the paparazzi would probably not have been capable of being published, whereas they would have been in Germany, to strive for some kind of European norm in relation to the law balancing privacy and the freedom of expression. But I wonder, perhaps, could he answer, in the context of the globalized world and in relation to information technology and the news media, there is no other area that's so globalized as that. What would benefit his client if there were a European norm, but you still had paparazzi prepared, as in the case of Diana in France, to take photographs which might not be capable of being published in Europe, but would be everywhere else in the world, the US, Canada, South America, the Far East perhaps. Is it the case that there would be really little more protection than there is at the present moment when you take the two analogies and place them together side by side?
Est-ce qu'il y a d'autres questions? Monsieur Ress, en anglais ou en allemand?
What would be better? I think for both parties it would be better if I put the question in German.
Okay.
Ich habe eine Frage an beide Parteien. Die erste und vielleicht mehr zu dem Vertreter der Beschwerdeführerin. Wie war die Situation eigentlich in diesem Beach Club in Monaco? Wenn ich das recht verstanden habe, war es ein Privatclub, für dessen Eintritt man relativ hohe Gebühren zahlen musste, und stimmt es, dass das Fotografieren in diesem Club verboten war? Das möchte ich gerne bestätigt haben. Das heißt, die Beschwerdeführerin konnte, wenn ich das nach den Regeln dieses Beach Clubs nehme, davon ausgehen, dass sie im Beach Club selbst nicht fotografiert werden darf. Erste Frage. Zweite Frage. Welche der Vertreter der Bundesregierung hat bestätigt, dass im Prinzip jedenfalls die Beweislast die Beschwerdeführerin trägt, dass aber diese Beweislast durch die Darstellungslast des beklagten Presseunternehmens gemildert wird? Könnten die Parteien Auskunft darüber geben, welche Auswirkungen sich rechtlich aus einer Umkehr der Beweislast ergäben, wie wir sie ja im deutschen Recht auch im Deliktsrecht bei Umweltschäden oder bei der Arzthaftung und so weiter haben? Wie würde sich eine solche Veränderung der Beweislast, das heißt, das Presseunternehmen muss zunächst einmal beweisen, dass der oder die Betreffende sich an einem öffentlich zugänglichen Ort ohne räumliche Abgeschiedenheit befand, auswirken? Und die dritte Frage ist eigentlich die, zum Zeitpunkt der Fotos war die Beschwerdeführerin unstreitig, und wenn nicht, können Sie das darlegen, noch sogenannte First Lady des Fürstentums von Monaco.
Est-ce qu'il y a d'autres questions? Est-ce que vous êtes prête à répondre ou vous avez besoin d'une petite pause? Vous êtes prête à répondre, Monsieur Prinz? Et Monsieur Stoltenberg?
Wir benötigen keine Pause.
Je n'ai pas entendu la traduction. Qu'est-ce qu'il a? Monsieur Prinz, je vous donne la parole.
High Court, I may answer the question regarding the global protection first. I think that the more and the higher the market value of these pictures is, the more there is an incentive for paparazzi to follow and pursue my client. And the more we can lower the market value, the more we will reach a situation when you can enjoy protection of privacy. So already that the pictures can't be sold in France, the price that you can get on the international market is lower because one market is missing. Now, if you make these paparazzi pictures and you can sell them for 10,000 euro in France and for 10,000 euro in Germany and for 10,000 euro in Spain, for example, the incentive is very high to do this constant spying and observation. And the more protection you get and the more markets you cannot sell these pictures to, the higher the level of protection gets. It is, at the end, a very commercial enterprise to spy on my client and sell the pictures. And if we can get rid of some of the markets, and if we could get rid of all of the European markets, that would give a big relief. That's one part of the answer. The second part of the answer is, if I can say that as an expert for international paparazzi photographers, because I'm dealing with them since 18 years in my legal practice now, in the US and in Europe specifically, you have different groups of people that are spied on. In the US, it's basically actors that are spied on, and they are subject to paparazzi photography. In Europe, it is my client and, of course, actors and, of course, sports people, but it's a different group of people. So if those that live in Europe and are prominent in Europe have protection under the European legal system, that will award them a large degree of privacy compared to what they have today. On the contrary, if you have a legal system in France that prohibits these pictures and makes them illegal, but you still have a market all over Europe for these pictures, and especially in Germany, where we have many of these yellow publications, our client who lives in France on French territory and her children go to school in French schools, the protection that is awarded to her by the French legal system does not work at all, because on French territory she's constantly pursued because the pictures shall be then sold in Germany. I may answer your question. Regarding the beach club, yes, your impression from the files you read is correct. It is a private property, the beach club. It is a private property, and if you want to go there and swim, you have to enter and pay a very high fee, and on these private premises it is absolutely prohibited to take photographs, and if you would enter and try to take photographs of other guests there while they swim or sunbath, you would be kicked out of this property immediately. It is prohibited. So yes, your assumption is correct. The princess could of course expect to be in full privacy there, but someone managed obviously to get on a roof of a neighboring house, that's what we assume how these pictures were taken, and spy with a telephoto lens into the property and take the pictures. The second question was regarding the burden of proof. How would be ein Beweislastumkehr, whatever that may be, what effect would it have? In the moment we have the following situation. If our client embarks on beach holidays and she is on the beach 2 weeks from 10 o'clock in the morning till 6 o'clock in the evening, and during 2 weeks of beach holidays she may wear 4 different bathing suits, and then a week later we see the paparazzi pictures in the magazines. We do not know at which day, at which time they were taken. And beaches are sometimes empty and sometimes not. So in these lawsuits regarding the question of local isolation, we have said to the courts in Germany, we cannot tell you whether there is local isolation because we don't know which day it was. So now the courts have established that the media companies have to tell us which day it was. That is what happened in this burden of proof situation. So now we know, out of these 2 weeks of summer holidays, it has been Tuesday the 24th at 6 o'clock in the afternoon. Well, we still don't really know how many people were on the beach at that time. And you may recall from what my colleague said, representing the Federal Republic, he assumes local isolation if you go to an empty beach at midnight. So we really have to show a lot. If we then know it is Tuesday the 24th at 6 o'clock, we then have to have witnesses to prove that there was no other person on the beach to enjoy protection of privacy. Now, how would it be if the burden of proof would change and the photographers would have to prove that it was not a situation of local isolation? I don't think it really would change a lot, because we would still have the risk of the lawsuits. Once we enter the lawsuits and sue the media company, most of the cases we don't really know which day it was she was horseback riding, where she was caught on her bike. So we don't really know what kind of risks we run into if a photographer shows up as a witness and says, well, there were 3 other peoples biking there, or 2 other peoples on this paddock. So we run into many, many costs. I may point that out for you, High Court, as well. We're doing these cases for the complainant here since 1992, and my friend Alain Toucas is doing them for almost as long in France. The complainant has run many, many high material risks and paid for many, many lawsuits to get some protection of privacy. And of course, we do not run blindly in these cases. We try to establish before that we have a chance to win them, because otherwise she has no privacy and the costs on top of that. So therefore, I think if you turn around the burden of proof, it would not make a difference. Your last question. Was she the First Lady of Monaco at the times that these pictures were taken? No, clearly she has never been the First Lady of Monaco. She has never fulfilled any public duties in the state of Monaco. She is the son of Prince Rainier, she's the daughter of Prince Rainier, and that's it. And when we have the Red Cross ball, the Croisière Rouge, or we have the Bal de la Rose, she may sit with her father at the table and she may greet the guests, but she has no official function in the state of Monaco, except for being the daughter. And, I may add, she doesn't even reside in Monaco. She lives close to Paris. Thank you.
Monsieur Prinz, est-ce que vous voulez répondre à la plaidoirie du gouvernement ou vous n'avez pas besoin de cela?
No, I think I already responded in some ways in answering these questions. Thank you.
Merci bien. Monsieur Stoltenberg? Monsieur Uli?
Ich möchte die an uns gerichteten Fragen beantworten, wenn ich darf. Zunächst, was den Beach Club von Monaco anbetrifft, möchte ich lediglich hinzufügen, dass es sich zwar um ein privates Gelände handelt, aber natürlich um ein öffentliches Freibad in dem Sinne, dass gegen Entrichtung der hohen Eintrittsgebühr jedermann Zutritt hat. Es handelt sich also nicht um einen privaten Club in dem Sinne, dass nur Mitglieder dieses Clubs Zutritt hätten. Das lediglich als kleine zusätzliche Anmerkung. Zur Frage der Beweislast. Ich möchte noch einmal betonen, dass bei keinem der Fotos, um die es hier geht, die faktischen Fragen streitig sind. Es geht lediglich um eine Frage der Subsumption, um eine Frage der rechtlichen Beurteilung dieser Sachverhalte. Wo diese Fotos gemacht wurden, war vor den Gerichten nicht streitig. Würde sich viel ändern, wenn man die Beweislast umdrehen würde? Ich würde dem Vertreter der Beschwerdeführerin darin beipflichten, dass sich nicht sehr viel ändern würde, nämlich aus dem Grund, dass wir schon bisher eine abgestufte Beweislast haben. Die Beschwerdeführerin muss derzeit dazu vortragen, ob diese Fotos in einer Situation der Abgeschiedenheit gemacht wurden. Anschließend muss aber die Presse sich dazu äußern, wann diese Fotos gemacht wurden. Wenn als erstes die Beschwerdeführerin die Situation der Abgeschiedenheit bestreitet und anschließend die Presse darlegen muss, wo diese Fotos gemacht wurden, denke ich, dass der praktische Unterschied verhältnismäßig gering wäre. Das ist im Grunde alles, was wir zur Antwort auf Ihre Fragen zu sagen haben. Danke.
Nous arrivons au terme de l'audience. Je remercie les comparants qui ont assisté à la Cour par leurs interventions. La Cour va maintenant délibérer sur le fond. L'arrêt sera rendu ultérieurement. Les parties seront informées de la date de prononcer. L'audience est levée.